Hey guys, so this is me Shagun Srivastava, and today we are going to discuss the topic the tort of nuisance. So the word nuisance, it has been derived from the French word which is called nuire, which simply means to annoy or hurt someone. See, a person is entitled to use his property and it should be without interference, and if that outside agency interferes in someone's personal property, then it is known as the tort of nuisance. It is basically an injury or infringing the right of a person in the possession of the property. For example, an improper interference in the terms of health, safety, or comfort can be termed as nuisance. Many a times we get confused with the term nuisance and trespass. So, trespass is basically a physical interference which is direct with the possession of the land, and nuisance is an injury or infringement to someone's right who is in possession of the land. For example, interfering in the right of way is an incorporeal right over property and it does not amount to the nuisance. Okay, and in simple terms, if interference is direct, then it is termed as trespass, and if it is consequential, then it is termed as nuisance. Coming upon the definitions, so many authors and jurists have defined nuisance in their own words. So according to Blackstone, nuisance is anything that worketh hurt, inconvenience, or damage. Means it causes hurt, inconvenience, or damage to someone's property, then it is nuisance. Then according to Stephen, nuisance means to be anything done to the hurt or annoyance of the land tenant or hereditament of another and not amounting to trespass. Means it simply defines the difference between nuisance and trespass. Then coming to Winfield's definition, so nuisance means unlawful interference with person's use of enjoyment of land of some rights over or in connection with it. Means the connected part is also a nuisance which causes the interference or violations of someone's personal rights. Coming upon the types of nuisance, so we know that basically there are two types of nuisance: private and public. So private nuisance is something which causes disturbance to a personal person. Means any single person is responsible for nuisance and it causes interference and violation of someone's personal rights. Okay, the remedy is provided in private nuisance for the damages, and private nuisance can be also defined into two parts, that is damage to property and second physical discomfort. In case where there is damage to property, any injury will be sufficient to claim the compensation or remedy. For example, smoke, gas, noise, water, trees, or animals. It means in terms of these disturbances, and in case of physical discomfort, the act which is interfering the ordinary comfort, means the simple comfort of a man is disturbed. For example, from carrying out any trade which is causing nuisance, means any noise pollution or kind of that comes under private nuisance. So the essentials of private nuisance are unreasonable interference, damage, or loss. Interference should be with respect to enjoyment only, then it will be coming under the private nuisance. Coming to public nuisance, so public nuisance, it causes interference to large number of people, means as a whole. So it covers public at large and it is punishable as an offense also. It covers several type of crimes like safety, health, uh, threat to comfort, welfare, or morals of the community. So this offense has been defined under section 268 of IPC also, and the remedy available in public nuisance are injunction, abatement, fine, or sentence also. See, fine and sentence is most important remedy of this nuisance. Injunction in an order which stops the defendant from doing an act, means the act which causes disturbance or interference, injunction puts a stop on that very act. Coming to abatement, so abatement of nuisance refers to destroying of a nuisance by a party who has been harmed. So the party who has been harmed, they stop it by some act. So this is abatement. Fine or sentence or a remedy or compensation can be used. In case of public nuisance, fine can be imposed, means the sufferer can claim the damages or compensation from the party for the violation of his rights. So important case laws related to nuisance. So first case is Dr. Ram Raj Singh versus Babulal. So in this case, what happened is that there was a grinding machine of a defendant which generated very much dust particles and polluted the atmosphere of the chamber of a plaintiff, and it caused a physical discomfort or inconvenience to the plaintiff. So as a result, what happened? The plaintiff suffered much loss as compared to other public. So it was held in this case that special damage to the plaintiff should be provided because he has suffered much more discomfort from the grinding machine which has created noise in the atmosphere. So although there was no nuisance to general public, but the plaintiff had suffered much more damages, so he was awarded with special damages and compensation apart from general public. Next case in the row is Rose versus Mills. So in this, what happened? The defendant had wrongfully obstructed the defendant from transporting his goods through the creek, due to which he had to transport his goods through land, because of which he suffered extra cost. Means the way through which he had to transport his goods, he was subjected to barriers around across that way. So which resulted in extra cost of the transportation. So it was stated that act of the defendant had caused a public nuisance, as the plaintiff successfully proved that he has incurred several losses over other members of the society, and due to this he had a right of action against the defendant for claiming the damages and compensation. Next case is also same as the earlier case, that is Winter Bottom versus Lord Derby. In this, what happened? Defendant agent, he blocked the footway of a plaintiff. So as a result, plaintiff brought an action that he had to go by another way and had to incur some extra expenses in removing the obstruction. So it was held by the court that plaintiff cannot recover damages, that he had not suffered more damages. The difference between the two cases, you can see that here the damages were not provided to the sufferer because he had not suffered that much loss as compared to other public. So this was the case. Then coming to Radhe Shyam versus Gur Prasad. Here, the injunction was obtained from restraining the defendant from installing a flour mill in the plaintiff's area. So, it was stated that a substantial addition to the noise by running of a machine, it causes physical disturbance and discomfort. So, it amounted to nuisance, and damages should be provided. Coming to next case, that is Attorney General versus PYA queries. In this, it was held that nuisance from vibration causing personal discomfort was a sufficient means to cause public nuisance. Means in this question was raised that can vibration cause the personal discomfort. So it was held that it is sufficient to cause a inconvenience to the person, and injunction was rightly granted against the query owners, restraining them from carrying on their functions. Coming on the conclusion, so according to law, nuisance is a person's behavior or physical condition that hurts or offends another person and is the basis of claim. So this concept has been developed from English courts. It is almost a codified law, and its growth and expansion is the result of interpretation in order for striving justice to each and every person and maintaining the rule of law along with good conscience and justice. And this very subject allows people to regain their personal rights from the violations and infringements that they suffer from the general public. So this was all. Thank you for watching the video, and please like, share and subscribe the Law Minds for such informative videos.